She hit him. She did not realize it.
There is zero chance this was an accident.
Dad, I think I struck something.
I didn't do anything wrong. Karen said that she remembered leaving him at Waterfall.
Karen, we saw you outside of my sister's.
There was another car that I hadn't recognized before. It was a dark SUV.
I've noticed a male and a female in the car.
Did anybody see anything? What happened? And there was one individual that replied several times, I hit him, I hit him.
I hit him, I hit him, I hit him.
I hit him, I hit him. Oh my God, I hit him.
It was several times.
Did you hit him with your hand? Did you kick him? What happened? She just repeated the phrase over and over again, I hit him, I hit him.
Says, I remember, all right, backing up and hitting something.
She kept saying, this is all my fault, this is my fault, I did this.
I said I hit him. It was preceded by a did and proceeded by a question mark.
About to go on trial for murder. Why are you smiling? Your boyfriend is dead.
On the same joke, right? I don't envision myself having the white picket fence bullshit.
I hope she did it, and I hope she gets away with it.
The defense claims that police framed Karen Reed. This juror agrees.
I believe there was conspiracy here.
I rather explain everything else and I did not hit John with my car. I can't make it sincere enough.
It's not a prosecution, it's a persecution of Karen Reed.
What is also clear from the federal grand jury is that this was an investigation which was initiated by the defendant and Mr. Yannetti.
A friend and colleague of Brian Alberts called me on February 2nd.
No, that's not true. That's not true. When I showed up, when I got to them, they're confused. Dave Yannetti's looking.
Well, I haven't talked to Dave Yannetti.
And he had a very distinctive voice, very gravelly voice.
If I knew anything firsthand, they would know about it.
I didn't know what he knew or didn't know. I didn't know how he knew it.
I saw your stuff. I followed you morning tonight. And I'll tell you, yeah, I mean, believe me, I'll call you Clarence. If I learn anything firsthand, you're going to know about it too.
There's something else going on here, pointing to a potential other suspect.
Can I ask you, how did you know Colin Albert was in the house?
Who?
How did you know Colin Albert was in the house?
Probably through you. I don't even know Colin Albert.
Okay, you're aware he was beaten up by Brian and Colin Albert.
Did you tell the attorneys that, or David Yannetti or whoever, when you didn't mention any Colin Albert to them?
I didn't even know Colin Albert.
Okay.
That Brian Albert, his wife Nicole, his son Brian Jr., and Caitlin are not targets of the federal investigation, and I've been given permission to disclose that in open court.
Every bit of discovery that the federal government has from the state case was provided by Mr. Yannetti.
I don't even know what you're talking about. What do you mean?
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Of a massive cover-up.
I didn't think I hit him, but could I have clipped him? Could I have tagged him in the knee and incapacitated him? He didn't look mortally wounded as far as I could see.
Karen Reed is 1,000% guilty.
I said, John, can you just run in there and
There is a piece of me that wants this woman to get away with murder.
Which I assumed was going to be in moments. Or that he'd yell to me from the front door, Kay, and it pissed me off.
John, I hate you!
Because one, I didn't really want to be there. Two, I had to go to the bathroom. Soon thereafter, within Dennis probably 2 full minutes, I start calling him. So I kind of slow rolled it off the street, and I'm hoping that as I slowly edge my way down the street, he's going to say, "Wait, Karen, where are you going?" I was home within probably 7 minutes.
John, I'm here with your kids, and nobody knows what the you are, you pervert.
I called him just over 50 times.
50 times?
Yep.
50 times. Well, that's normal, right? You drop someone off at a party and just immediately start calling them 50 times, asking them where they are. That's super normal. I mean, the more that you look at this case, the more that it's shocking that anyone is still believing her. You have to be breathtakingly stupid to still believe her at this point. I think that a lot of them don't care that she's guilty. I mean, I think that's what it is. It's more about her fighting the system and winning than it is that they believe that she's not guilty. I just can't for the life of me understand how anyone could think she's not guilty. Like her story has changed so many times. Thanks for the sticker, Robert P. It's unbelievable. Thank you for joining, Annie McGee. I just don't know how. I mean, like, if we look at that juror, the juror suddenly is saying he believed the conspiracy. Like, that's not what he said when he was on Turtle Boy. It's not what he said before. And now, all of a sudden, he's like, I believe there was a conspiracy. Like, he is such a lowlife. You know, it's so grifting off of this. Like, going on Inside Edition to suddenly believe the conspiracy. Like, what a joke that guy is. I mean, even his first like interview with Turtle Boy seemed very it didn't seem like it was true. Certain things like saying, oh, I thought it was more John O'Keefe's fault because he wanted to keep drinking. Like, that is not a normal thing to think. That is something that Karen Reed in her mind probably thinks because she's crazy. And so I feel like he's been talking to her, and that's where he got coached a little bit. I don't really know. But I mean, what is wrong with that guy? He's just doing any interview he possibly can. And I watched The Greasy Lawyer You Know last night. I mean, he is the greasiest lawyer I've ever seen. And I thought that he was like I think that he's kind of decent, some of the things that he says, but like he's so off base on so much of this case because I don't think he's been following it closely enough. But I mean, why is he so greasy? I know he's in Florida, but like, my God, it's not even that hot right now. It's like, we can stop drilling in the Gulf and just like extract oil out of his T-zone. I mean, come on. His perspective is absolutely, I think some of his perspectives are accurate, but like when he was talking about Michael Morrissey's statement, it's like you're like over a year late to this party. You have no idea what was going on, why he made that statement. That statement was made because everyone in this case was getting harassed. Free Karen Reed. She's the only person involved in this case that's free. Everyone else has like been suspended from their job, has been harassed at work, has quit their jobs, has, you know, been followed to their house, has had all this stuff happen to them on the online. People have dropped out of school or dropped off of teams, and it's like their lives have been interrupted. And any normal person should look at this case and be like, if my kid, you know, was witness to something, a lot of them didn't witness much. You know, they witnessed her pounding 9 vodkas, which are on camera anyway. But if your kid witnessed something, you want them to tell the truth, right? And that's what they did. And because they did that, they're getting harassed and they're getting hate and they're getting all these things. And everyone should know this is not right. This is not what you should do. So it's just a little weird that, you know, that people can't see that people are seeing more like, oh, it's them tainting the jury pool. No, the jury pool's been tainted because there's been false information for a year about this goddamn case, and it's the simplest case possible. I mean, what in the world? There's so much evidence. Proctor is back working, apparently. That's interesting. I know he had his hearing got continued multiple times, so what was his third hearing? Did that already happen and he just didn't lose his job? I don't know. I have no idea, but I think this next hearing, it's probably going to last a day or two, because there's a ton of motions, and this is going to shape the case. This is going to shape exactly what the trial looks like. I think it's almost more important than what happens at trial, is the limits of what can be said, what's going to be covered, what you can argue, what you can't. And if you think about it, like what really is going to change from the first trial? Like we know that we have text stream data, more text stream data, potentially. I mean, maybe we don't. I don't know. Was there anything else, like new evidence? I think it's really just going to be a difference in style, a different argument, and potentially certain things being excluded. That's what they're going for anyway. Excluding, I mean, God, they want to exclude everything. So, I mean, everything can go different ways. Let's see if I can share this screen. Share screen. Share. This one. I think I can make it bigger too. If I get rid of that and get rid of that and zoom in. Get rid of this. All right, so this first one, this is the Commonwealth, and it's about protective orders to shield litigants and third parties from unwarranted disclosures and as a practical matter to facilitate the discovery necessary for a trial. And it's an order, so this means that she already ruled on it. So certain things will be protected. I think we know that. So this one, it's Karen Reed is asking to bring in a chalk. This one I feel like is sketchy. And it's all about the glass on the bumper. They want to, like, to me, like reading through it, and even that woman's testimony was confusing. But it's like, how important is it? Is this going to be the most important thing for them? Maybe it is. But to me, it doesn't change anything to me. Like, if there was glass on our bumper, like, that wasn't from his cocktail glass, like, okay. Like, what does that tell me? It tells me that it wasn't planted because they wouldn't have planted the right fucking glass, right? So, like, I don't know. Like, glass can come from a lot of different things. And if she's around driving drunk all the time, like, who knows what else she's done, or if she carried her glass out. So basically they're saying, like, they saw him on footage. Like, this is like one of their big ones. I feel like this is something that they really want to get in. They're saying her testimony was more than an hour, and it was 37 pages of trial transcript, and it was super confusing. And they want a chalk to map out where the glass came from. I mean, I could say, like, yeah, they should have it. It'll make it easier, but I feel like they can't be the ones that are producing it, because it's definitely not going to be honest, right? It's going to be tricky. It's going to be, because they're slimy people. We know it's not going to be a really honest thing. So whatever, they want a chalk, and a chalk is basically just like a visual aid, and, you know, mapping out where all the pieces came from, I guess. They say, like, she had to keep looking at her notes and reading from her notes. And so they're like, she's an expert and she can't even keep track of all the labels and the evidence. So we need to give this, like, poster, which I don't know. I don't know what, at the end of the day, what it's going to change. But we'll see. We'll see. I think the Commonwealth is going to argue about that. I mean, do they get to see it first? Because I would want to see it. Maybe we're going to see it, and they're going to say, like, okay, but you can't be saying this. You can't be labeling it this way, because they're so sketchy. I can't even believe in the last trial that they allowed in Microdot's mock-up of the house, because it was, like, flat. It looked like the house was, like, right on the street. They didn't have, like, enough bushes over in that corner. Like, it just was not accurate. Like, I feel like that was a chalk, wasn't it? Did that have to be allowed in? I'm not sure. So this is another one from Karen Reed. She doesn't want the Aruba incident brought in, blah, 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 prior bad acts. So in a lot of cases, you can't bring in prior bad acts. But this is a domestic violence case, right? So, and this is directly related to like what they think happened that night from her phone calls, from everything. It's, you know, it corroborates. It's her same. She had the same mental fit that she did that night. And furthermore, Brian Higgins, like they were texting about it, and it was a constant thing that was brought up. I think in between Karen and John, it was something that was brought up in text. So it's not like it was just like a blip on the radar. This was like a major incident, and this was the incident that helped him decide that he needed to get rid of her. So they don't want it in. I feel like it has to come in because the texts between Higgins are in there. That's why they were breaking up, like a big part of it, right? So, I mean, she was even bringing it up to Higgins saying like, oh, he cheated on me in Aruba. So, I mean, it's just weird. I don't think it's, I mean, it just supports the domestic violence thing that she has rage, and it is a fundamental rule that the prosecution may not introduce evidence that a defendant previously has misbehaved, indictably or not, for the purpose of showing his bad character or propensity to commit the crime charged. I don't think it's a propensity to show, like, to commit the crime charged, the Aruba incident, but it shows, it supports, like, what her rage voicemails were that night, right? It gives you more insight into it. And it's what they were talking about all month. It's, you know, this was 4 weeks prior. 2 weeks after this, she's trying to bang Higgins while he's sitting on the couch with them watching a football game. And then 2 weeks later, John O'Keefe is dead. So it's very relevant. It's very current. And it's a domestic violence case. So it would be hard. I'd be hard pressed to think that they're not going to bring this in. I don't even think that argument, I don't even care what the argument is. I think they tried to exclude this last time too. And it was allowed. It should be allowed. It's a domestic violence case. Like, it has to be allowed. All right. So this one, defendant Karen Reed, to exclude certain witnesses before and after testimony, namely the portion of the motion referencing text messages that are subject to a protective order. I think that this is, you remember like a couple weeks ago, they had that text message of Proctor texting Lally about Alan Jackson is an asshole or something. I feel like this is what this is about. Maybe. So a copy of the motion with all references to and copies of the text messages that are subject to a protective order redacted, such that they are not visible to the public. Okay, whatever. And then we have, Elizabeth Little. The redacted. So this is the redacted copy of what they were just referring to, I believe. So exclude certain witnesses from the courtroom before and after their testimony at trial. They're bringing up that Brian Albert, Colin, and Jen McCabe were in the sitting with the O'Keefe family during the closing arguments, and that one juror came and complained. But I don't even believe it. Was it Ronnie? Like, who was it? Like, from what he originally said, not what he is saying now, but what he originally said, nobody believed the conspiracy. Everyone believed the witnesses. So why would they be intimidated by Jen McCabe and Brian Albert and Colin Albert? They didn't believe the conspiracy. So I think it's bullshit. The judge can just be like, this wasn't said under oath. There's no affidavit. This was a juror said this to someone that was writing a Vanity Fair fluff article for Karen Reed. So I don't really give a shit what they say. So they all sat in the gallery during closing arguments, blah, blah, blah. Colin Albert. I just want to see if they forgot anyone. Brian Albert, Nicole Albert, Colin, Julie, Chris, Jennifer, and Matthew. And Brian Higgins. Weird. Exhibit A is all black. This is the text messages, the Lally ones, most likely. There might be something else that we don't know about, but. All right, so this one, she's asking for a view, and it's weird. So it's the same view that they had last time. They want to view the house. They want to view the car in front of the house. But Karen Reed wants to be there during the view, which I think is really freaking weird. I don't know if that's normal. Like, you're not supposed to talk to them, I don't think, except to direct them what is what. But that's really weird that she's going to be there. I mean, I would say don't let her be there. Because I just feel like she's just, like, the way that she even acts in the courtroom. In a courtroom, she doesn't even act normal. She's making jokes. She's laughing at her brother. Like, she's going to be like, oh, look at that. Like, she's going to be making comments. I wouldn't let her go. I would shackle her to that table. That's as far as she should go. So this one is expenses incurred by Miss Reed for expert voir dire. So I don't know why they're filing this really, because that wasn't discussed in the first trial, like how much you paid the expert. I've never even seen it in a trial where they discussed that. So I guess it's because they paid Dr. Wolf and Dr. Rentschler that $30,000 or whatever, $25,000. And they're just saying like, oh, it's because of the voir dire that they had to pay this money and that they don't want the jury to know about it or something. But like, why are they going to know about it anyway? Like, I don't know. I really don't know. I've never seen this brought up before, so I just don't. I mean, I know that they're saying they don't want that $23,000 brought up or whatever. I think that is going to be a big part of this, these motions, is they're going to argue about how they're going to present that, whether it's, I don't know, they're not going to want to talk about the money for sure. But they also just, I mean, I feel like the simplest thing is you just can't be like saying, oh, these are independent witnesses hired by somebody else that we never talked to. Like, that's a lie. You can't say that. But how much you paid them, like, I don't give a shit. I don't, you know, like, are they going to go through all the witnesses and tell them? And maybe the jury does have access to that information. I don't know. So in this one, Karen Reed is asking to conduct a panel voir dire of the jury venere on the following subjects: whether previous experiences with the jury system or criminal legal system, characteristics of the case, including the media attention or personal characteristics or concerns of the prospective jurors, would impair their ability to be impartial, whether prospective jurors are biased in favor of law enforcement or have law enforcement related knowledge. They're looking for a bunch of cop haters, like that's what this is. Whether prospective jurors hold strong personal beliefs about operating a vehicle under the influence of alcohol. They're looking for prior DUI people that will be sympathetic. Whether prospective jurors have been involved in or have close friends or family members who have been involved in domestic violence relationships. Whether jurors have been involved in a motor vehicle crash. I mean, hasn't everyone been in some sort of motor vehicle crash? Have been the victim of violent crimes, whether prospective jurors understand and can be impartial in light of the procedural protections afforded to defendants in criminal trials. I mean, I know what they're going for. I mean, whatever. We'll see what she rules on it. But they want a bunch of like conspiracy-laden criminals that drink and drive that are going to be sympathetic to her. That's what they want. They don't want anyone that's, you know, realistic. They don't want the realists. They want these, you know, tinfoil people. And they're going to go on and on and on and on. Okay, they just want them to ask about those subjects, which I don't know what's on the list of things that they normally ask them. I don't think they televise that. That part's all secret. All right, so Karen Reed. The defense learned that the Commonwealth was having improper conversations with witnesses while they were in the middle of their testimony. For example, on cross-examination, Brian Albert indicated that he had spoken with Assistant DA Adam Lally over the lunch hour while the court was in recess. All right, so yeah, I'm sure that people are going to have small talk. So they're just saying she's going to order this. I'm sure. Basically just saying that you cannot be talking to law enforcement, victim, witness, blah, 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 once they have taken the stand. I think she probably had that last time too. So this one, she wants to exclude irrelevant, inadmissible, and prejudicial evidence regarding alleged harassment and or intimidation of witnesses. Good cause exists for the impoundment of this motion because it makes reference to grand jury proceedings. Of course she doesn't want that in. I think it comes in. I mean, the thing is, they're allowing in, or last time, I don't know if they're going to allow it in this time, but last time they allowed in all kinds of nonsense about Colin Albert's like sophomore year threatening kids, about his bloody knuckle picture, you know, all that stuff. Like, we knew everything about every single witness from like 20 years back, but we didn't know shit about Karen Reed. And the stuff, the harassment of the witnesses, that is something that Karen Reed has done currently since this crime, and it definitely should be included. Like, it's just such a joke that we know every single thing about all the Alberts and their relationships, fights that they got into 20 years ago, DUIs that they had 25 years ago. Like, it is a joke. None of those people are on trial. None of them are charged with a crime. Like, why would that be? Why do we know all that? We don't know anything about Karen Reed. We can't even find a single boyfriend that's alive. All right. So then this one, she's asking to like not bring in like the blood alcohol ethanol concentration test performed by Good Samaritan Hospital. They both filed a motion on this. So the other one is they want the blood. I mean, why would, it's a freaking DUI case. Why would the blood alcohol be excluded? I don't even think they have a good argument for it. All right. So what is their argument? I mean, they're trying to like get it excluded on a technicality. Like, come on. So annoying. So desperate. And this ID show, I just think it's going to be off the charts because the comments that she's making, it's just insane. She's laughing about John O'Keefe getting killed. Like, she's laughing about it. She's like, I just can't help laughing. So funny. So I think this is probably about Richard Green, because who has a prior criminal history that we know of besides Richard Green? This will be I want to hear if the Commonwealth is going to argue for it, we might get the details, which would be good. I think it's probably about Richard Green. I mean, I don't know if it's relevant, but I think it is relevant because he lied to the police and made a fake police report, right? That's what the whole thing was. So why would he not lie for money? He would lie for nothing, basically. Like, he was arrested saying that like the bouncer or something like pushed him to the ground, but then there was a surveillance tape showing that he just fell. And, you know, he pressed charges and filed a police report. And, you know, once he saw the surveillance tape, he got rid of it. But like, that just shows that he's not honest. So I think that it should be in there. And confidential arrest records, especially if it's Florida, it's not confidential. So why? That's not confidential. Like, shut up, Karen Reed. All right, Elizabeth Little. So they want a stenographer. Blah, blah, blah. They'll get this, I'm sure. Sequestration of all witnesses expected to testify at trial. And so the Commonwealth is asking for exceptions for the family of Karen Reed and Paul O'Keefe. I think it's Interesting. I wonder why they didn't call Peggy O'Keefe last time. I think they're going to call her this time. Because the thing is, Karen Reed went on, what the hell, Dateline, and said, they pulled in behind my car. I know that they were looking at my taillight, and they were thinking, like, you hit him with your car. I don't think they even noticed her taillight, right? Like, I don't remember them testifying to that. So she's the one that felt uncomfortable because she knew she hit him with the car and wanted to leave, right? And she's trying to like put it on Peggy O'Keefe. So I think that, they'll have that interview hopefully to play, and then Peggy O'Keefe would be like, no, I just knew that she was acting weird. I didn't see anything. It was packed with snow, like the back of the car had snow all over it. We didn't know what we were looking for. We didn't notice. And then I kind of hope that they call William Reed and Nathan Reed because they were all there too. Did they see the taillight? I mean, all these people need to be questioned about, like, did they see the taillight? The only reason I think that people saw it was because Karen pointed out to them. Just like a body in the snow. You don't notice it if you're not looking for it, right? So, I don't know. So, we'll see what happens. I mean, I think she's going to allow it. I think it was allowed last time. Paul O'Keefe, it was sequestration for everyone except for the family. So the Commonwealth just wants to be able to ask, like, do you see this crazy woman with blood on her face that was saying, I hit him, I hit him, I hit him. Do you see her here? And, I'm surprised they even have to file a motion for that, to be honest. Like, I just thought that was, like, par for the course. I see that in every trial. They want photographs of the victim, John O'Keefe, and graphic photographs of his injuries. I mean, I'm sure that will be allowed. The manner of death, like that whole thing, I just feel like this is so desperate. Like, I mean, like the defense is fighting to have the manner of death, the means of manner of death. Usually it's redacted because it's the jury's job to figure it out. I mean, I think that it means nothing. Like, to me, like, if I was a juror, I would not give a shit. Because if someone's hit with a car, how the frig would the medical examiner know if he was hit on purpose or if it was an accident? Like, they just going to put something on there based on, like, hearsay evidence from other people? That stupid medical examiner, though. I mean, medical examiners are always a problem in these cases. They don't want to commit to anything. They never want to say anything's impossible. They never want to say, like, it's likely. They always just, like, they're never the ones that seal the deal on either side, ever. I guess that's the way that they are trained to testify. I have no idea. But it's frustrating because every single trial I see this really obnoxious avoidance of having any opinion. So this one, I mean, so I wonder if there's anything in these records or what this is about. I guess it could be one or two things. If they wanted her framed, why invite Karen Reed back to John's? Yeah, I mean, nothing about framing Karen makes any sense. I mean, she was supposed to come in. She was the one that was pushing to keep the party going. So it's like they show up. There was no expectation that he was getting dropped off there at 12:30 at night, right after the bars closed, without a ride home. I'm sure that he could have gotten a ride, but that would have been said before she dropped him off. Like, Karen Reed, no, her story doesn't make any sense. in that new documentary, the ID documentary too, she is saying that she called and texted him within 2 full minutes or something. Whatever she says, 1 minute, she starts calling. She's like, because I didn't want him just to not see my text, so I started calling. But we have no phone calls until she's speeding across town connected to his Wi-Fi. So, no. But this could be one or two things. Either there's no RMV, like no other accidents for her car, or there is one, because she's driving around drunk all the time. I don't know. I mean, I feel like, yeah, bring him in, whatever. We'll see. Maybe there's something there. The Commonwealth wants to ask about criminal records of jurors. Yeah. I mean, I thought that was always the thing. I thought that was like par for the course. You ask them if they've been involved with, if they were related to a felon. Usually it's not like misdemeanors or minor crimes, but like felonies. I would think that, yeah, you should ask them that. So this is the Commonwealth. The court orders the defendant to make a satisfactory offer of proof prior to calling and summoning Norfolk DA Michael Morrissey and victim witness advocate Stephen Nelson as witnesses, and for finding that the district attorney and Mr. Nelson is not subject to any order of sequestration. So I remember there was something with the witness advocate Stephen Nelson. I can't remember what it was, but it was like something that was told. I feel like it had to do with maybe Jen McCabe. They were like, who told you that? I can't remember what it was. Something. I feel like it was something super inconsequential, but you know how they like to blow up everything in this case and, make a mountain out of a molehill about everything. I have not heard what happened with the ID people, but the cuts that I've seen of it, it's bad. Because I mean, I think that they did multiple takes, and like she's just like, it's so hard for me to say it with a straight face. Like, I did not hit John with the car. Like, I don't know. Like her demeanor, she loves this attention. She loves it. She is glowing. She reminds me so much of what's her name, Daybell, Lori Daybell. Like Lori Daybell was acting like she was a contestant on Price is Right when she was on the stand testifying about her kids being killed. And so like Karen gives out that same energy. So I don't know what it is. Lori Daybell was in a cult. She loves Jesus. God help me. So yeah, so this whole thing, I don't know what it is. Like they need to we'll find out what it is. I'm sure they're going to argue about like why they need to call Michael Morrissey. It's probably about his statements. And then Steve Nelson said something to somebody. Maybe it was something about, I think I remember. It was someone asked about the phones, if they could get rid of the phones. I think it was Higgins said like Steve Nelson. Maybe he asked Steve Nelson or something like that. I think that's what had to do with the phones. Medical examiner was a stand-in for the day. Wish the in-house he was on duty, Matt. May have had a more concise determination. Love your mindset. Yeah, I mean, I don't know. Michael Proctor said she's a whack job. I mean, I think that's his name for a lot of people, but she was kind of a whack job. She was like, I don't know. She's, well, it's possible. Everything's possible, lady. It's blunt force trauma. Anything's possible. Like, give me a break. Brennan has not made a motion for the ID discovery footage yet, which sucks because, I mean, I think this is it. Like, this is motions to eliminate. Like, it has to be done now. So I don't know. Maybe I think they had a deadline too, where everything had to be filed. I don't know what the deadline was. I don't know if anyone knows the date, but he's going to see it on Monday. I mean, he might have already seen some of the previews, and I think that some of the previews are pretty bad. What else did she say on that? Oh, I think I have. Let's see if I can find it. me stop sharing this and let me find. I don't know if it's going to be sideways or something because I just screen recorded it. I don't even remember where I saw it. 2 hours and runs her boyfriend over. So we don't care how cute she was as a little kid. She was still narcissistic back then too. Like, who calls themselves the beautiful, the talented? Ugh. But I digress. Where is this? All right, so we have this. This is they're talking about the, I mean, I think this is going to be an interesting argument about it. So like Hank Brennan basically is saying they need to show the extreme nature of whatever they're a witness for. They need to like make sure it's because he's the district attorney, right? I doubt they're going to show it. I doubt that I doubt that they're going to call him as witness. So then the Commonwealth wants chalks. I feel like Lally used a chalk at the end during his closing argument, right, to show the timeline, to show the voicemails. So it sounds like something similar to that. Videos from the crash reconstruction. I mean, the crash reconstruction is going to be super interesting. The reconstruction at One Meadows Ave, that's going to be interesting. Because, I mean, she committed to, like, that's where I broke it. And so, like, I think they can easily prove that that's not where she broke it. So, I don't know. So, it's going to be up to the judge. I feel like that's kind of an easy one. They're just going to allow it. They intend to call Jessica Hyde and Ian Whiffen. They want him to be able to do a demonstration of how the wall file works. I'm sure that will be allowed. I mean, I can't believe we're still even litigating the goddamn House Long to Die in Cold thing. Yeah, I mean, it's like anything that's on a big poster board typically, but it can also be projected on a screen. It's still called chalks. So it's like a markup of something. But I think originally they were called chalks because they were like on a big white poster board, and Karen Reed's team did bring in a lot of them, like when they brought in like the judges or messenger about the judge, Aunt Bev. Remember, that was like a chalk. They brought in pictures of his arm. That was a chalk. So this one is the Commonwealth wants to allow into evidence John O'Keefe's statements to his niece, nephew, family members, and friends regarding the defendant's intention. Regarding the defendant's intention to end his relationship. Wouldn't be the defendant, though. Regarding the victim's intention to end his relationship with the defendant. And statements about the tumultuous nature of the relationship, which are relevant to the victim's state of mind. I mean, it's a domestic violence case. I mean, this has to come in. I feel like if she excluded that would, I mean, how can you exclude it in a domestic violence case? I mean, she specifically told, like, the medical, like, when she was being sectioned, that the last thing that they said to each other was they were fighting. So that's not over a phone call. That's not in voicemail that they were fighting. So this is the Commonwealth saying, allow the blood serum conversion, blah, blah, blah. I would assume that they're going to allow that. So the Commonwealth wants to order counsel to refrain from making any reference before the jury of any alleged bad character or alleged misconduct of the victim or any witness without prior court permission. Specifically, the defense has made allegations about civilian witnesses and law enforcement witnesses, and the public has been saturated with unfounded claims of bad acts by the Commonwealth witnesses. At the previous trial, the defense lodged a slew of claims of alleged bad acts of witnesses. Indeed, the defense has engaged in a comprehensive campaign to inundate the public with its claims and has repeatedly declared or implied that the Commonwealth, the prosecutors, the court, trial court employees, and witnesses are all corrupt, declaring that virtually every civilian witness, police officer, and first responder was complicit in the cover-up of evidence and implying that nearly every witness is a liar. Such allegations have no foundation nor bearing on any issue in this case and would constitute impermissible bad character evidence, whether during the opening statement, during cross-examination of any Commonwealth witness, during direct examination of the defendant's witnesses, or during closing argument. Defense counsel should be restrained from making such references unless obtaining prior court approval. A judge may properly exclude evidence that is introduced merely to show the bad character of a witness. Right here, I'm thinking of Colin Albert's Snapchats. Further evidence of prior misconduct may not be used to impeach a witness's credibility, except by production of records of criminal convictions pursuant to the limitations and requirements of blah, blah, blah. So I would say that's stuff Chris Albert getting in a fight 20 years ago and Lank, I don't even remember, Lank helped him out. Colin Albert's I don't even know. His Snapchats where he's threatening some kids sophomore year. But then also to not impeach them further, but no be to impeach witnesses. So if Colin Albert said he was never in a fight and they found a video of him in a fight, this sounds like that would also be excluded according to this, because it's saying only except by production of records of criminal convictions. So interesting. Evidence irrelevant to the issue at trial or to a witness's reputation for truth and veracity is inadmissible to impeach a witness. Any bad character evidence of infidelity, propensity to consume alcohol, or the defendant's suggestion without any factual support that every witness is a liar or participant in an unfounded scheme to frame the defendant has no bearing on any of the issues raised in this case. I think he's also the propensity to consume alcohol. She has said it a million times how John was in his drunkenness, falling down in his drunkenness. He was so drunk in Aruba. She has said it so many times, that it's his fault. And even that juror, Ronnie, came out and said oh, he's the one who wanted to drink more, so it's his fault. So he wants even that excluded. So the proposed evidence only serves to disparage the victim's and witness's character and to distract the jury, which I agree. So this is about the internal affairs investigations pending against any law enforcement witnesses. So this is, it could be Proctor. I mean, that internal affairs, I think they looked into everybody. So they don't want to... So it's saying that the findings do not relate to any bias exhibited by those. So the internal affairs investigation is, it's not showing, it's irrelevant. Well, that's what they're saying. I don't know. I don't know what she'll do on that. I mean, it's not like they found that they planted evidence or they did anything. It's did he call her a whack job balloon knot? Yes, he did. Is she a whack job balloon knot? Yes, she is. It sounds like he was telling the truth to me. Oh, man. And so then they're talking about, the Sergeant Lank thing that occurred nearly 20 years ago. I mean, I don't even remember Sergeant Lank testifying that much. Was he even that relevant? He was a first responder, I think. He went in the house with somebody else. But, I mean, come on. So his case was dismissed, whatever it was. All right, so that's the internal affairs. They don't think that should be brought in. They don't think the old 20 years ago, case against Lank should be brought in because the charges were dropped. Come on. And so this is the big one. The third party culprit defense of the Commonwealth is requesting the court to preclude the defendant from raising a third party culprit defense, which I think she should. She should grant this motion because every single piece of it was fabricated. The federal investigation turned up nothing. And they never even named a third party. Like, they just said everybody's bad, everybody's in on, everybody's lying. Like, that's not what a third party culprit defense is. So he's quoting her, Karen, just to be clear, you didn't do it. We know who did it, Steve. We know. That was in the video at the beginning. And we know who spearheaded this cover up. You all know. After the first trial, the defense position began transformation. We're going to retool everything. And maybe some things will stay, some more, but we're going to shuffle a lot of things around. Most recently, in its Fox 25 sit-down, the defense responded to the question, in your opinion, there have been a few names that have surfaced in the third-party culpability theory. Who do you think, if John was beaten up and attacked in that house, who did it? Alan Jackson quickly jumped in and said, we don't know. And then Karen said, we don't know. Counsel furthered, and it's not for us to know. Somebody other than Karen is responsible for that, for the killing of John. But who it was specifically, others know, and they're not talking. I mean, yeah. The evolving responses have vacillated from an unidentified certain villain to not knowing who is responsible, and have been the hallmark of the defense's third-party culprit claims since its inception. The defense is not entitled to simply engage in scorched earth tactics, making baseless and incendiary claims about witnesses without any evidentiary foundation. Now, the scorched earth approach, that is, I think even Alan Jackson or Karen Reed said it in a text to Turtle Boy saying it's scorched earth, we're just going to go after everybody. You know, we're going to go after Julie Nagel. We're going to go after the blonde girl that was a nurse. And like, I think that people that come into this case, not realizing that it wasn't like a police officer party. That's what, you know, it's kind of marketed as. He was found out this outside of a house of a police officer party. It was his son, whose birthday it was. He was 23 maybe. And his girlfriends were sitting in the house drinking, celebrating his party. And the adults, his parents and his aunts and uncles, came home after the bar. That's not a police officer party. You know, Brian Higgins and John O'Keefe were also invited, but it was mainly family there and their sons' girlfriends, like young adults, not all related people. Like, you think a 22-year-old girl is going to be like, oh yeah, let me just lie for all these people. Like, come on. So the court ordered, based on the offer of proof on Friday, I'm well within my rights pursuant to the case law to exclude the third-party culprit defense. So this was last trial. I'm not going to do that now. I'm going to give you a chance to develop it through relevant, competent, admissible evidence. But you cannot open on it. So that is my ruling on that. So she gave them some leeway, and they screwed her. They screwed her. They duped her in every chance they got. They duped her. So despite the court's clear ruling, the defense launched into its third-party claims from the beginning of its opening statement. Karen Reed was framed. Her car never struck John O'Keefe. She did not cause his death, and that means somebody else did. And I remember seeing Peggy O'Keefe in the background, like putting her head in her hands, because it was specifically said they could not say it in their opening statement. They did it anyway. So that should be a sanction. Because the judge doesn't want to, like, you know, call a mistrial. But they're not going to follow the rules. So they should not be allowed any leeway whatsoever this time. And so that was followed by, because the Alberts were involved and because they had close connections to the investigators in this case, Karen Reed was framed for a murder she did not commit. Nobody believed it. Only idiots believe it now. And so the evidence identifying or establishing the third-party culprit was never forthcoming throughout the trial, and to this day continues to be non-existent. They still haven't proved it. After 3 years, the defendant has yet to provide any evidence as to whom they suggest is the third-party culprit responsible for the victim's death, or any evidence of alternative circumstances that would have caused the victim's death. The absence of any evidentiary basis to support a third-party culprit defense was clear before the start of the first trial. To accept the defendant's third-party culprit defense, the court would have to find the defendant demonstrated that the acts of the other person are so closely connected in point of time and method of operation as to cast doubt upon the identification of the defendant as the person who committed the crime. Now, when we think about like what really went on, what was going on in these people's heads, like the Alberts and everything, like this guy's found outside your house, like what I think is that they knew he was hit by a car early on. They knew that she did it, but then they were probably texting like, what time did this person leave? What time? They were worried about the other people that were driving that night. So Higgins, Caitlin Albert, anyone else that drove that night, and then Matt McCabe. So those were the 3 people that left. So they probably were texting each other like, oh, what time did you leave? And did you have a lot to drink? And so those kind of texts were, I mean, probably happening. And that's where like the people can be like, oh, that's a conspiracy. Like that's probably they were a little bit nervous about that in the beginning. And they took that and turned it into something else. And that's what this is. And it's very obvious that that's what happened. And like Karen Reed's defense should have, went with someone else hit him with the car, right? Because there were other people drinking and driving that night. Now her pieces to the car matched, but you could still say like, oh, maybe it was planted. And really it was like Caitlin Albert's car and someone fixed it, or Brian Higgins' Jeep and it was fixed in the background. That would have been a much more realistic defense. But I think that it was just so, I mean, everything was matching her car, like everything, and then the texts and everything just lined up too quickly that they had to just go scorched earth and just blame everybody. But now they're saying like, oh, it wasn't a car at all. Like they've been saying that. So like that they can't even go that direction. I know, don't give them any ideas. They can't go that direction because their whole thing is that car did not kill John O'Keefe. Which I think was very stupid of them to go that route. Because they're relying on ARCA, right? To say like, oh, we don't think that he was hit by a vehicle. So, blah, blah, blah. I think that she should not allow it. I mean, it's not going to go over well with the free Karen Reed freaks, but they have not established anything. Like every single piece of evidence, like Colin Albert's bloody knuckles. Then we see there was a picture of him with clean knuckles like a week after or 2 weeks after this happened. We have Jen McCabe's Google search. If that did happen the night before, like who is she in cahoots with? Because she didn't call or tell anyone about what her Google search revealed. So like, what was she sending a bat signal up into the sky? And Colin Albert was like, got it, Jen. I mean, wouldn't he just do the search on his own? Like, come on. None of it makes any sense. Brian Higgins, I don't even know. His time frame is the only one that like, I don't know. We're not like sure like when he left the house or whatever, but there's no motive there. And like, just look at all of her actions. Like she obviously hit him. All right. So then what else do we got? For the foregoing reasons, the defendant should be precluded from alleging that any other individual is culpable for the victim's death, as there is no relevant or substantially probative evidence to justify the admission of such a speculative claim. Furthermore, despite this court's previous order denying the defendant's request to raise a third-party culprit defense during the defendant's opening statement at the first trial, Yannetti was permitted to declare 3 separate times that Karen Reed was framed. Should the court preclude the defendant from raising a third-party culprit defense counsel should be ordered to confirm their argument to the orders of this court. Yeah, I mean, well, what is she going to do? Stop him mid-sentence and be like, can't say that? I mean, I guess she could interrupt. I don't know. I've never seen that happen. I guess she could. I mean, she interrupted Lally to tell him, like, you only have a minute left. You have 10 minutes left. And each time she did that, it, like, totally threw him off his game during the closing. So I guess you can interrupt. Maybe if you're not the timekeeper, but, like, as the evidentiary trial court keeper of the truth, you can interrupt. All right, so this one, they want to give a written questionnaire to prospective jurors. Of course, I would think that's normal. They're going to declare, they're going to allow that. So this one, they're trying to exclude references that, so Trooper Michael Proctor, in the first trial, he was like, he showed up at my sister's school and was, I don't even remember what he said. He was parked in the parking lot. I think it happened like the day before his testimony, so it was like fresh on his mind, and they don't want that brought up. They're saying like what he said was false. Like they have a bunch of, I started reading through it, but I'm just like, I don't give a shit. It's like, it's his interpretation of what was going on. There was a lot of shit going on. He was being interrogated by the FBI. He has this guy harassing him, making up lies. There were so many lies spread, and then he's outside the sister school. Like the conclusions are logical for him to jump to. Sister thought she was going to be subpoenaed or something. Like they're saying, oh, well, they were there for something. I don't even give a shit. So Trooper Proctor should be disallowed from making these types of inflammatory accusations against Miss Yannetti. I mean, I don't even think that the jury cared. I don't think it was that important. But I feel like that's his interpretation. He was under a lot of stress, I'm sure. I mean, his testimony was rough. Like, that man probably did not sleep for days. That was stressful for everybody. And I'm sure he'll never send a text message again. I mean, I'm sure he's afraid of sending any texts now. So this is just the case. I mean, it's so, I just feel like this is like, why are they even thinking about this? Like, who gives a shit? All right, so then this is the ARCA. This is going to be a big one. So they want to be able to say that it was the U.S. Attorney's Office that initially hired the employees of ARCA. So I just feel like this is a slippery slope, and I think that she's going to land somewhere in the middle. Because if you say that, that means that, you know, the prosecution could be like, okay, well, what ended up happening with that investigation? Oh, no indictments, like nothing. Oh, nothing. And like, who gave that evidence? Why did you only have partial evidence? Like, who only gave you those certain pieces of evidence? Oh, it came from the defense. Like, I don't know. I don't even feel like jurors are going to really know the roles of the U.S. Attorney's Office. I don't know. I just think it's, let's see what the conclusion is. It's a long, boring, goddamn thing. And, you know, like, what's his face? Lester. What the fuck is his name? Oh, Alessi. He's going to go on and on and on about this for, like, days. He should not even be allowed. She should kick him off, too. He's just the worst. This is definitely an Alessi one. Let's see if his name's on it. Oh, my God. It's long. David Yannetti, Alan Jackson, and Alessi. Oh, yeah, all of them signed it. Why isn't Elizabeth Little on these? She always has her separate one. All right, let's see. There's only a couple left. Blah, blah, blah. Does it not initially retain or involve these experts in the investigation of the witnesses? I mean, the real question is, like, why why are they still pushing with these witnesses? They raised $700,000. They can't afford to hire a witness to do a real accident reconstruction. They just want this partial one that was like incomplete information. Yeah, I wonder why. Blah, 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 blah. Okay. Now comes the defendant, Karen Reed. During the retrial in this matter, in the interest of promoting judicial economy, the efficient administration of justice, and the preservation of issues. What? As grounds for this motion, Ms. Reed states the court's general order that counsel not state grounds for their respective objections before the jury led to extensive discussions at sidebar, which lengthened an already extensive jury trial. I mean, I think this is the way they do it in Massachusetts, so... Ms. Reed further states that the inability of defense counsel to state grounds for objections could lead to their inability to preserve issues for any necessary appeal. Stating the basis for an objection in a word or two will not cause either side any prejudice. I mean, I prefer to hear what they're objecting. I feel like a lot of the times I know, though. And, like, they're lawyers, so they should know. They should know. So, I don't know. Whatever. Is this the last one? No. I mean, I doubt that she's going to grab that one. Allow counsel to state grounds for objection. Blah, blah, blah. So this is David Yannetti in support of this. Based on our legal research, at least. So he's like saying that it could be an appeal. Blah, blah, blah. Okay, David Yannetti. So they're prohibiting the Norfolk District Attorney and Massachusetts State Police from having juror contact because the exhibits supporting the motion as well as a discussion of those motions are subject to this court's orders of impoundment. And the text message exchange, which included Lieutenant Fanning and Trooper Proctor, must both be filed under an order of impoundment. So they're just barking up the wrong tree. I mean... this is the last one, I think. Okay, it's the same thing. Juror contact. And that's all happening on March 18th, which is next Tuesday. So on Monday, Karen Reed's ID special is coming out. So hopefully... I'm sure Hank Brennan's going to watch it. And hopefully, like, if there's something good in there that hasn't already been done, he can ask for... I think the judge would probably allow it if he just filed a motion quickly. He should probably just write it up now. Hank, if you're listening, you should write that motion up, get it ready, and get it ready to send... and see what's in that documentary, because there's going to be at least something that's good. And even if there's nothing, or it's already covered in other things that we have, just file it away. But, my God. But I don't know. Next Friday, not Tuesday. Oh, it's next Friday? It's the 21st? I thought it was the 18th. I know her show is coming out the 17th. I think it's a docuseries, so I think it's going to be... I think it's going to be like The Staircase. Did you guys watch The Staircase? It's like following that guy that, you know, he found the woman at the bottom of the stairs, his wife. But... I think it's going to be in that style, but I don't know. She just says so many random ass things. But until next time, I think, you know, there's going to be a lot to talk about. I mean, there still might be more things coming. But there's going to be a lot to talk about in the next 3 weeks. And then the trial is going to start unless it gets postponed. Yes, Michael Peterson. So the CR case, he had a documentary crew following him around. And I think it's a similar thing to this where he wanted to play the victim like and get his story out in the public. Yeah, she seemed, I don't know. I think in the documentary maybe we'll see more. But I know when she was being arrested that second time, Proctor was like, you guys see how crazy she is? So I'm hoping that, we see some of the craziness on video, on body cam. I don't know how they got that video. I don't know. I don't even think we've seen it, have we? We've seen bits and pieces. But that's all, folks, for now. So keep me posted if you find anything good, any good clips or any good information. And we will see where this lands. Have a good night.
You have to believe all of the McAlberts who testified. And so am I correct in saying that they found the McAlberts to be convincing witnesses and truth tellers?
Correct. She stated to Miss McCabe, could I have hit him? Did I hit him?
She didn't say that. Who said? Jen McCabe says she said that.
I hit him. I hit him. I hit him.
The firefighter said that she said that too.
Who's the firefighter?
Repeated. I hit him.
Katie McLaughlin. Who's her best friend?
She's not a close personal friend of mine.
John O'Keefe and Karen Reed never entered my house.
12 people didn't see a guy go in the house. That's what you were relying on.
12 people also didn't see a body when they left.
I did notice something out of the ordinary, like a black blob in the ground by the flagpole.
I also was not looking out my window.
Okay. Let me ask you this. Did anybody in this courtroom ask you if you were looking out your window?
I wouldn't be staring at her grass, so no.
Okay. I didn't ask you where you were staring.
Karen, we saw you outside of my sister's.
I saw the black SUV arrived.
There was another vehicle in front of us.
Up the hill towards us.
On the same road coming from the opposite direction.
It was a black SUV.
I've noticed a male and a female in the car.
A car length and a half in front of me.
There was another car that I hadn't recognized before. It was a dark SUV.
Saw it pull up, stopped, pulled up again, stopped, pulled up again by the flagpole, stopped. That's all I saw.
Just turned around and looked through the blinds.
It wasn't going 50 miles an hour, correct?
I mean, I didn't have a radar gun on me, but no.
Goes up the driveway and approaches the side door.
0 people have said that they saw him enter the home.
Because he's dead.
And at any point in time, did you see anybody exit from that vehicle at any point?
No.
You never saw anyone around the SUV, correct? Correct.
Ryan Nagel didn't see him go in the house because he ran. Because he was real quick. Because he ran because it was cold out.
He must have ran real fast.
That makes sense to a lot of people. What doesn't make sense to anyone?
It does not make sense.
His phone did not enter that home.
Oh, really? Actually, he did.
That address. One of those individuals is dead and the other individual is alive. Ultimately, and there's damage to the vehicle, then that individual must be responsible for.
So he was going up and down the stairs between 12:21 and 12:24.
But Waze says he didn't get there till 12:24.
The Waze does not say that.
They were with the ascending, descending stairs.
What the defense presented was concrete evidence by the most highly credentialed people and experts in this country.
There were also some puncture wounds in that shirt.
No!
I'm sorry, puncture wounds in the shirt?
Puncture holes.
Are you aware that Celebrite has had to modify their software based on misinterpretation of data, as you've done in this case?
Yes.
No!